Recently, staff for the City of Toronto cleared out a homeless encampment in one of the parks in downtown Toronto, and in the process arrested a member of the press, placed him in handcuffs, and removed him from the scene, which engages some very serious questions about the rights that people have and the limits to those rights under Section 2 of the Charter. So I'm going to take a look at that arrest today on Don't Talk TV. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Recently, a viewer sent me an email bringing my attention to recent events in the City of Toronto, which involved the clearing of an encampment of homeless individuals. And as part of that, a member of the press was arrested. And what really caught my attention when I read the article that the viewer sent was that this wasn't merely, quote-unquote, a member of the alternate media who perhaps the government would argue isn't actually a journalist, isn't a member of the press, but it appears to be someone who works for the so-called mainstream media. So that really caught my attention. So today on Don't Talk TV, we'll take a look at the facts surrounding that case. We'll take a look at the laws surrounding the eviction of homeless people from a park, and then we'll look specifically at the Section 2, freedom of the press, and how that may interplay with the power of arrest that employees of the City of Toronto would have had in this circumstance. So I've got an article here from Yahoo News from the Canadian Press entitled, "Toronto Starts Clearing Another Encampment." This is from July the 20th, 2021. So just to give a bit of background here, it states that police and city inspectors moved to clear another homeless encampment at a public park in downtown Toronto on Tuesday, arresting several people, including a photojournalist with the Canadian Press. So just scrolling a bit down in the article, here's the details of that arrest. Quote, Chris Young, a longtime freelance photographer for the Canadian Press, was reporting on the encampment clearing when he was arrested by a city worker for trespassing. He was released with no charges after he was escorted out of the closed-off area in handcuffs. Young said in an interview that he was the only visible member of the media on site when he arrived early in the morning. He said the area was not fenced or manned by staff at the time, but that changed as more people enforcing the order arrived. He said he pushed back on requests to leave the area where staff were speaking with the encampment residents being evicted. Just before 9 a.m., Young said a city worker told him he had a choice to leave or be arrested. So he indicates that he chose not to leave of his own free will. He was handcuffed by a city worker, then 2 police officers led him out of the fenced-in area. He was issued a trespass notice, which doesn't carry a charge but bars him from returning to the site for 90 days. So, as I said, this is something very out of the ordinary. I can't think of the last time I've seen a case where a bona fide journalist, a mainstream media journalist, was arrested for practicing his trade and reporting on incidents that were happening. But before we get into the arrest of the journalist, let's back up a bit and look at the first question of, did the city workers have the right to be evicting homeless people from a park? Some might say, don't homeless people have a right to live somewhere? A helpful case for looking at this is Batty et al. And the City of Toronto et al., a 2011 Ontario Superior Court of Justice case that dealt with the eviction of Occupy Toronto protesters from a park in downtown Toronto. So that engaged some of the similar arguments in terms of Section 2, the right to freedom of expression, and specifically political expression, and whether it was legal for the Occupy Toronto protesters to be evicted from the park. Paragraphs 13 and following of that decision give a good discussion of the limits of charter rights, and so I want to quote them at some length here. Starting with paragraph 13 states, "The charter does not remove the need to apply common sense and balance to the way we deal with each other in our civic relationships. The charter does not remove common sense from the process of trying to figure out how to balance the competing rights which now characterize our contemporary Canadian polity. On the contrary, the Charter speaks of reasonable limits on guaranteed freedoms, thereby signaling that common sense still must play a role, indeed a very important role in that balancing exercise. Nor does the Charter remove the obligation on all of us who live in this country to share our common urban space in a fair way. The Charter does not permit the protesters to take over public space without asking. exclude the rest of the public from enjoying their traditional use of that space, and then contend that they are under no obligation to leave. And that goes back to a comment that I've made a number of times, that there have to be reasonable limits. Charter rights are not unlimited. Otherwise, the example I've given is that religious freedom, if that was completely unlimited, would allow for people who follow ancient Aztec or ancient Mayan religions to kidnap people off the street and cut their hearts out to sacrifice to the sun god, and then be free from charges of kidnapping or murder because they're exercising their freedom of religion. Now that's an extreme example, but it underlines the reasoning that there is to the reasonable limits outlined in Section 1 of the Charter. And as the passages I just quote would show, homeless people essentially squatting in a public park and taking it over and thereby excluding the rest of the public from enjoying that park, those competing rights need to be balanced, and in the end it seems to me fair and reasonable, especially given the context that the homeless people were being offered alternate accommodations, that they be trespassed out of the park so that all the inhabitants of Toronto can potentially enjoy that park. So let's take a quick look at the powers that the city workers would have been relying upon to be making these arrests, including the arrest of the journalist. So I've opened here the Trespass to Property Act, and that act, under Section 2, says that every person who is not acting under a right or authority conferred by law and who, without the express permission of the occupier, the proof of which rests on the defendant, enters on the premises when entry is prohibited, or engages in an activity on premises when the activity is prohibited, and does not leave the premises immediate after he or she is directed to do so by the occupier, is guilty of an offense, and on conviction is liable to a fine of not more than $10,000. So that would be the section that they would say the homeless encampment was offending against. Then the arrest power comes from Section 9 of this Act, which indicates that a police officer or the occupier of a premises or a person authorized by the occupier may arrest without warrant any person he or she believes on reasonable grounds to be on the premises in contravention of Section 2. So under that section, employees of the City of Toronto would be authorized to remove people from City of Toronto property. City of Toronto being the occupier, employees of the City of Toronto being authorized individuals. Now, there's two concerns that come up specifically with the arrest of the journalist. One, is the journalist actually trespassing as regards Section 2 of the Trespass to Property Act? And if they are trespassing, is considering them trespassing a reasonable limit of Section 2 in the particular circumstance of the case? And I should pause quickly to just reiterate what Section 2B of the Charter of Rights and Freedoms entails. That everyone has the following fundamental freedoms, including B, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now let's return back to Batty in Toronto. Page 53 of that decision lays out the test. Section 2B of the Canadian Charter of Rights and Freedoms provides that everyone has the fundamental freedoms that I just outlined. The analytic approach adopted by the Supreme Court of Canada to claims under Section 2B requires a court to pose and answer three questions. 1. Does the applicant's conduct or statement have expressive content? 2. If so, does the method or location of this expression remove that protection? And 3. If the expression is protected by 2B, does the government action or legislation infringe that protection either in purpose or effect? So let's take that quickly a step at a time. 1. Does the conduct have expressive content? This would seem quite clear. Obviously, a reporter, a journalist, observing and reporting on events occurring is clearly expressive content. 2. Does the method or location of this expression remove the protection? Now, I suppose the city would argue it does because they were evicting people. No one was allowed to be in that park. They needed to get everyone out and clean it up. But there's also the method. As I said, it would seem that this reporter was just there recording. They weren't blocking city workers. They weren't obstructing them anyway. I would suggest that their protection under 2B is not removed by simply being present and recording. This is something that journalists do all the time. It's very standard. And the very uniqueness of this situation is what suggests to me that the reporter didn't run afoul of Part 2 of this test. And then we look at 3. does the government action or legislation infringe that protection? And I would suggest in these circumstances, it certainly seems to infringe that protection. They prevented the reporter from reporting on what was going on and from seeing whether human rights were being violated in the manner in which the homeless individuals were being evicted from that park. So it would seem that the city workers ran afoul of this section. Now, a final consideration, and this harkens back to my video on citizens' arrests, and I recommend you to take a look at that for more detail. But as I outlined in that video, any arrest is governed by the principles of proportionality, necessity, and reasonableness. In handcuffing this reporter to remove them from the scene, does that comply with those three requirements? How is it proportionate or necessary to place handcuffs on this reporter? They could have simply guided this reporter out by putting a hand on their arm and moving them out of the park. The use of handcuffs seems to be excessive. And in the circumstances, an arrest that exceeds the law is an assault. And specifically, it's an assault with a weapon here. Because again, if we look back at my previous video talking about the definition of a weapon under the Criminal Code of Canada, a device that's used to secure someone, like handcuffs, is a weapon. So objectively, it would seem that these workers, in my view, could be in danger of a charge of assault with a weapon for the manner in which they arrested this journalist. This video is not legal advice, of course. If you're in a situation where you need legal advice, call a lawyer. You can call myself or another lawyer. My 1-855 number is listed below along with my website. And if you have any suggestions or ideas for show topics you'd like to see me cover, please send me a suggestion. You can post in the comments section below, or you can send us an email, and the email address is listed below. And if you found this video at all helpful, interesting, and informative, please like, share, subscribe, and follow us on social media.